My name is Scott Thorpe. I'm with the law firm of Kunzler IP, and I'll be talking about some of the subtleties of copyright law. In particular, I'd like to discuss the concept of fair use. Of course, when someone holds a copyright, no one else can duplicate or copy that material, whether it be written material, a song, a sculpture, a painting. Copying of that protected work is basically forbidden, except under certain circumstances under the doctrine of fair use. So if you're using a portion, not of course the whole work oftentimes, except maybe for example for a painting or a sculpture, but if you're using a reasonable portion of the work for criticism, news reporting, teaching, scholarship, or research, that use of copyrighted work is protected. In determining whether or not the use of a copyrighted work is fair use, a number of factors are considered. The first factor is the purpose and character of the use. Was it commercial or was it nonprofit or educational? Obviously, if the use is nonprofit or educational, it is much more likely to be considered fair use. So if you're using an excerpt in a classroom, more likely to be fair use. But if you're using it in a magazine advertisement, more likely to be considered that it's not fair use. The nature of the copyrighted work is also considered. Was it a large novel with many pages of text, or was it a short magazine article? Was it a single image, or was it an entire movie? Another important consideration is the amount and nonprofit substantiality of the portion that is used relative to the copyrighted work as a whole. So for example, if you take out say a 3-second snippet of a movie, that's viewed much differently than the use of an entire image that is copyrighted. Basically, how much are you of that particular work are you using, and also how much of that is directed towards a nonprofit or educational use. Finally, the effect of the use on the potential market for the copyrighted work is considered. Does using it spoil, for example, the ending to a novel? Does it give away most of the value of the copyrighted work? Or is it merely there to educate or for purposes of criticism? These kinds of factors are very important in determining whether or not the use of a copyrighted work is fair use. The image on the left is of the Korean War Memorial in Washington, D.C. The image on the right is the Korean War Memorial postage stamp issued by the United States Postal Service. Now, the United States government owns the Korean War Memorial, but it does not own the copyright. The copyright is owned by the artist that created it. So that when the government tried to issue a postage stamp that depicted the Korean War Memorial, the artist sued, basically saying, no, you're using my copyrighted work without my permission, you can't do that. And the artist won because the courts held that it wasn't fair use, that the government didn't have the right to use the copyright, even though it owned the sculpture, because that was held by the original artist, and therefore the government had to get a license from the artist in order to issue the postage stamp. These two images are very famous works of art that are in the public domain. In other words, they were created so long ago that there's no longer a copyright on them. But what would happen if you found these images someplace, like for example on the internet? Would you be able to use the images on the internet which were made of the original works of art? And the answer is, well, that depends. The image on the left is of a painting, and in the United States, one appeals court has held that the image of this painting is not a copyrighted work. It's not protected simply because no originality went into creating it. In other words, all one had to do was snap a picture of it, and therefore there's no originality, so there's no creative expression, so there's no copyright. However, the answer might be different for the image on the right. the sculpture there of the thinker, because in order to create this image, one might have to make artistic decisions about what angle to photograph the sculpture, about lighting, about other kinds of things like that that would make each image of this particular sculpture unique. And so as a result, it might very well be covered by a copyright, and you might not be able to use that image if you happen to find it unless you got a license from the photographer. So what about pictures of buildings? Well, buildings are copyrighted works of art. They're copyrighted expressions, and so they are protected. But the copyright on an architectural work does not include the right to prevent someone from, for example, taking a picture of it if it's embedded in a location or visible from a public place. So if you're standing in a public place and you take a picture of a copyrighted building, you can distribute that. However, if, for example, that building, say, were completely on private land and you weren't taking a picture of a public place, then it would probably be protected by a copyright and you would not be able to distribute that picture. Now, an interesting example of copyrights has to do with the Eiffel Tower in Paris. If you take a picture of the Eiffel Tower during the day, then there's no need to get a license, because the Eiffel Tower obviously is now in the public domain. It was created a long time ago, and so an image of it is definitely not protected by a copyright. However, if you take a picture of it at night, then you're actually required to get a license, because the lighting adds originality to the tower itself, and it is recent, so it is still protected by a copyright. Parodies are considered criticism, and so even if the purpose of the parody is to make money, parodies are still protected as fair use. Here we have two images. One is one of the volumes of Tolkien's Lord of the Rings series, and the other one is a parody of it, put out by Harvard Lampoon, Board of the Rings. Now obviously, Board of the Rings is a complete parody, a complete ripoff of the Lord of the Rings. But because it is a parody, it's protected fair use. And so, of course, Harvard Lampoon can publish Board of the Rings, and there is no copyright issue. You're probably familiar with Margaret Mitchell's Gone with the Wind, and the book next to it is The Wind Done Gone, which the courts found was a parody of Gone with the Wind. And as a parody, it's protected as fair use. Now, The Wind Done Gone used the same plot as Gone with the Wind. It used many of the same scenes. It used basically quoted dialogue from Gone with the Wind. But because it was done from another point of view, and because it was done with the intention of criticizing the point of view of Gone with the Wind, it was considered a parody, and as a parody, it's protected as fair use, and as the little sticker on there on The Wind Done Gone says, it's the unauthorized parody, and so it is fair use and it can be published. Well, what about reference works? The book on the left is the Seinfeld Aptitude Test, and it basically was a number of questions and answers that were all taken from episodes of Seinfeld. Now, the courts held that this was not fair use of a copyrighted work, the copyrighted work being the television series. And the reason is the whole book is nothing but excerpts from the series. And so they reasoned because the book is all excerpts, it's all based on the series, that it is not fair use of the series, and so the publishers would have to get a license in order to publish the book. The book on the right is fairly infamous. It is the lexicon about the Harry Potter series. Now, this started off as a web page, and as a web page it was held to be fair use because it was mainly educational. Anyone could access it freely. But as soon as the author tried to publish it as a book, he was sued. And he was sued because he was trying to make a commercial use out of all the information that he had, and it was deemed that this commercial use was too much of the original Harry Potter series, or too much of the original text. And so the original version of it was not allowed to be published. He cut down the references to the original Harry Potter series and published this lexicon, which was held to be fair use because it used a much smaller portion of the original works. Characters are copyrighted. So for example, if you write a story about Superman, then you are violating the copyright if the story is basically centered on Superman, because the character is the story and characters are copyrighted. However, character types are not copyrighted. So for example, if you wrote a story about a caped hero that flew through the air and had X-ray vision, but the caped hero wasn't Superman, that's okay because character types aren't copyrighted. Similarly, plots cannot be copyrighted. A lot of people have noticed there are a lot of similar elements between the Star Wars plot line and the Harry Potter plot line. Well, that's because plot tropes simply can't be copyrighted. There aren't that many plot tropes, and so there's bound to be a lot of similarity between plot lines in different types of stories, particularly ones that share common themes like action and adventure or romance. So as a result, plots simply can't be copyrighted. This means no fan fiction. If you have any questions on copyrights or the various nuances of copyright law, please give me a call at 801-692-0493, or my email is sthorpe, STHORPE, @kunzlerip.com. Thank you.